Hello there, I'm Chichirize Patton. I'm an assistant lecturer, Kavala University, Faculty of Law, and I'll be taking you through sale of goods and supply of services, and specifically in Uganda. Of course, these principles run across regions and countries, but today we are specifically looking at the law of sale of goods and supply of services in Uganda. This course is very, very important to all of us, especially to us as lawyers, because we are able to know when people are doing transactions of sales. You're buying, you're selling goods, you're supplying services. What are those nitty-gritties that you have to make sure that you comply with? Because if you don't, then there is always someone, the person who is aggrieved, always come up and sue you. So every day we buy, we sell, we supply. So as we supply and sell, then there are things that we need to make sure of. So in my talk today, I will be looking at introduction and the laws applicable to sale of goods and supply of services, the purpose of the law, the nature and elements of the contract of sale, the types of goods, how do you form this contract, how do you distinguish, for example, the sale of goods and other contracts, how do you distinguish a sale and an agreement to sell, how do you, then briefly about the terms of the contract. We'll not go into details because this is sort of an introductory part, but I wanted to bring to light everything that may be covered in this course. Then we look at the duties of a buyer and the seller under the contract of sale of goods, and buyer protection challenges that are out there. Then we look at supply of services. When we look at the introductory part, we'll find that the objective of this course, we are to consider the principles that govern the sale of goods and supply of services. Remember, the sale of goods and supply of services forms a biggest percentage of transactions in Uganda every day. When you walk out of your house, you buy, someone sells, and we look at supply of services. There are big contracts that are taking place. So as a lawyer, you need to place yourself in a position where you're able to advise. It can be a seller, it can be a buyer, it can be a supplier, it can be a consumer. So we're also going to see that this law, the law of sale of goods and supply of services, lays down the terms intended to protect parties to the contract. Through studying this course, you're able to know the terms of the contract that are able to, to protect the parties, and that will give you the ability that when you're drafting a contract for your client, you're able to draft a contract that is going to protect your client at the end of the day and not bring you problems. There is when you draft a contract for a client and at the end of the day your client loses, ends up getting into problems. But remember, as a lawyer, you're supposed to protect your client with the advice that you give. Then we'll also be looking at the instances, in case of instances which may interrupt the smooth performance of a contract of sale or supply of services. What are the rules applicable? How do you handle those kinds of instances? And so the law applicable is the Sale of Goods and Supply of Services Act, Cap 292. We cannot divorce it from the Contracts Act, Cap 284, then Common Law and Doctrines of Equity, and then Case Law. So the purpose of this law, of this particular course, is that it regulates contracts for the sale of goods and the supply of services. Basically, it was put in place to make sure it regulates the contracts that come out of selling goods and supply of services. Then ensure dealings between buyers and sellers or suppliers and providers or clients that they are going to be supplying to. And also provide the performance of these contracts, that once you enter into a contract for supply of services or sale of goods, you make sure that you perform the contract. Otherwise, if you breach it, then you'll be able to pay some damages or pay big. So you have to make sure that you perform. And what brings that is that there is a law in place that makes sure that you perform. Then the remedies for breaches. If the sale of goods contract is breached, what are the remedies? And then the aspect of protecting consumers. You know, in Uganda, the aspect of protecting consumers is something that is coming up, and we are seeing this law being able to help us achieve that particular purpose. So when we go to the nature and elements of the contract of sale of goods, when you look at section 2 of the Sale of Goods and Supply of Services Act, you can shorten it and call it SOGA. It is sort of huge, SOGA. It defines a contract of sale of goods as a contract by which a seller transfers or agrees to transfer a property in the goods to the buyer for a money consideration called price. So that is a contract of the sale of goods. You transfer or you agree to transfer the property in the goods to the buyer for a money consideration called price. And when we look at section 3 of the same act, it defines a contract of supply of services to mean a contract where a person agrees to carry out a service, and whether goods are transferred or are to be transferred, or bailed or are to be bailed by way of hire under the contract, regardless of the nature of consideration for which the service is to be carried out. So if I can give examples, sale of goods, I think that is very common. You know, you buy matoke, you buy maize, etc. You supply, you buy items. So all those are in the categories of good. And later I'll be defining what a good is. And when we look at supply of services, we are looking at, for example, styling your hair. We are looking at dry cleaning. We are looking at the services that the hotels, all those are in the category of services. So we'll be looking at what a service is and what goods are. So when we look at the elements of a contract of sale of goods, number one is that when we look at elements, we are looking at also like characteristics. So one, it has to be parties. It has to be a buyer and there has to be a seller. So you can't say I'm under this contract and you're selling to yourself. No, there has to be a buyer, there has to be a seller. Then there is what we call transfer of property. When we talk about transfer of property, what we mean is transfer of ownership. So transfer of possession doesn't suffice. For example, if I have a phone and I press into I give it to someone else just for keeps, that does not suffice as transfer of ownership. And then for a contract of sale of goods, the subject matter must be goods. We later see the definition under section 1 of the Sale of Goods and Supply of Services Act. So there has to be goods, and then there has to be the price, which is money. So for a contract of sale of goods, the price we are going to see is money. So if it is other things, it is not a contract of sale of goods. If they are exchanging goods to goods, that is not a contract of sale of goods. Then we look at the elements of a contract of supply of services. We find that one, it has parties also. There has to be a supplier and a consumer, or we may call it client. For example, in construction, we call that a client. So it is a supplier or a consumer. It's also defined under section 1. We'll later go into details on what it means. Then there has to be consideration. Now, for a contract of supply of service, we look at the aspects of consideration as it is done in the law of contract. So we'll go to the types of goods. What goods are we looking at when we are talking about a contract of sale of goods? So when we are talking about the types of goods, section 1 defines what goods are. And when we look at section 1, it looks at chattels. Chattels, that is movable property. We look at embellments, that is we are looking at growing crops and anything that is forming part of the land. that is what we may call goods. So anything movable and anything growing as part of the land, it can even be an animal or some inborn animal, something that is yet to be born, but is within an animal. For example, when you have a goat and there is it is yet to give birth, so that can also be a good. So when we look at the types of goods, we have existing goods or future goods. Section 6.1 of the Sale of Goods and Supply of Services Act defines an existing good. And it says that this is the goods which form the subject of a contract of sale at the time the contract is made. So existing goods, like we are going to see, are goods that are available. You can touch them, you can see them. So what is what we mean as existing goods. But when we talk about future goods, we look at goods that are yet to be manufactured. So at the time of the contract was made, these goods were not yet manufactured. And then we have what we call specific goods. Specific goods are goods that are identified and agreed upon by the parties at the time of making a contract. For example, we can have 20, maybe 100 kilograms of rice, and you only need 5 kilograms. So once you remove the 5 kilograms and put it aside, that is what we mean as specific goods. You have identified them, and then you have agreed with the seller that that is what you want. So you look at section 1, it also defines what a specific good. Then we have what we call ascertained. Ascertained, those are the ones which are identified subsequent to the formation of the contract. So before the contract is formed, they have already been identified. So subsequent to the formation, these goods are already there and they are already existing. Then unascertained goods. We look at goods not identified and agreed upon at the time of making the contract. Then we have contingent goods. These are a type of future goods. So for them, they depend on upon a certain and uncertain contingency. So they may be got or they may not be. got. It's like when you say, if that mango tree gets ripe, I'll give you the mangoes. So it means that the mangoes, the supply of the sale of mangoes will depend on the mango tree producing those mangoes. So that is what we may call contingent goods. When we look at how do you form this contract then? How do you form this contract of sale of goods? So most sale of goods contracts are not very formal, but we are going to see how we can, as a lawyer, how do you advise your client? Section 5.1 of the Sale of Goods and Supply of Services Act says that these contracts may be in writing, it may be by word or of mouth, it may be partly in writing, it may be partly by word of mouth, it can be in form of a data message. So I can send you a message, I say, please supply this, and if I respond, that will be a contract. Or they may be implied from the conduct of the parties. So that is how a contract of sale of goods is made. But we are going to see under the Contracts Act, that is section 9.5. We are going to find that the contract, the law is saying that contracts that are above 500,000 shillings, when we turn it into currency point, that is 25 currency point. Each currency is at 20,000, so that is 500,000 shillings. So it says that those kinds of contracts shall be in writing. So as a lawyer, you have to encourage your clients to make sure that whatever they do, they put it in writing, because when they put it in writing, there is certainty of the terms of the contract that they have entered into. And also it will be easier to enforce such a contract because first of all, the terms are certain, and secondly, it is within the law, because the law is clear that a contract above 500,000 shillings shall be in writing. That is mandatory. That is what the law is seeking. So there is something about the sale of goods. When we are defining the contract of sale of goods, we talked about that the buyer, the seller must transfer or agree to transfer. And that brings in two aspects of a sale and an agreement to sell. So section 2.1 defines a contract. We had already defined it as a contract where a seller agrees to transfers or agrees to transfer for a money consideration called the price. Then an agreement to sell is defined as to mean where the transfer of the property in the goods is to take place in the future time. There is a difference between those two. Where there is a contract of sale and where there is an agreement to sell. For example, you see that for a contract of sale, it is instant, but for a contract of an agreement to sell, it is a contract that is to be at the future time, or subject to the conditions that may be fulfilled. So there are some main points of distinction. One is transfer of ownership. So when we go to a sale, and I want this particular topic always disturbs students, but you have to get it clear that at a sale there is transfer of ownership. There is transfer of ownership. The goods come from the seller to the buyer. So the seller is no longer the owner, but rather the buyer. So ownership changes hands. But when there is an agreement to sell, ownership does not change hands. Even if the buyer is already in possession of the goods are not his. It means that the ownership will pass at a future time. So the aspect of ownership, so it changes a lot of things. That in a sale, actually someone has a say. We call it, we call it jus in rem. Jus in rem. We call it jus in rem. And jus in rem is that you have rights against the whole world. So it means that once you buy your product, you have ownership against the whole world. It means that whoever tampers with your product, you can actually sue them. But when we look at the agreement, when we look at an agreement to sell with SELL, which is in the future, you have rights in personam. Rights in personam. So when we talk about rights in personam, rights in personam, it means that the buyer, the only rights he has is against the seller. All right? Against the seller. So it means if there is any dispute, the only person he can sue is the seller. The same applies to the seller. So that is what happens in a sale and an agreement to sell. Then about the risk of loss. Who bears the risk at that particular time? In a sale, remember, ownership has changed hands. So in a sale, trust me, the risk now goes to the buyer who now has ownership. But in an agreement to sell, the risk will stay with the seller because ownership hasn't changed hands. I'll give you an example. I can go to the bond, I buy a car, and we finish the transaction. But with a jam in, maybe there is a lot of jam in Kabale, I decide that I will not take my car that day. It will slip in the bond and I will take it tomorrow. All right? Then that particular night, maybe fire gets the warehouse and my car is destroyed. In that instance, the car I was already the owner of the car. The transfer had already taken place, so I will bear the what? I will bear the risk. But there is going to a bond house, the car bond, and then you check it out. And as you check it out, you say, I'll come back tomorrow and sell and buy this car. I'll come back tomorrow and buy this car. You have not yet bought the what? The car. The car still belongs to the car bond owners. And so, if fire destroys the house tomorrow when you come, you're still looking for your car because ownership had not changed hands. So the rule is that risk moves with ownership. Risk moves with ownership of what? Of property. Then when we look at consequences of breach, what if you breach a contract? The contract, what happens? What are the consequences? When you breach a contract, when it is a contract of sale, then you're going to bear, first of all, you pay the price, because remember, ownership has already changed hands, and then you can even pay damages. So you pay the price for the goods once you're a buyer and you breach the contract. And also, it means that you're going to do what? You're going to pay some damages. But when it is an agreement to sell, remember, ownership is not yet in the hands of the buyer. Therefore, the only thing the buyer can get is damages. For example, I'm looking at a situation where I'm not yet with the products, but maybe you delayed to bring the product. I can only sue for damages because they were not yet mine. Then when you look at the right of resale, the right of resale usually is for the seller once the buyer breaches the contract. So it is one of the remedies that the seller has once there is breach of a contract. But what I can say is that when there is a contract of sale, the seller has no right to resell the goods, even if they are in his possession. Because remember that the goods are not yet his practically, unless it was specifically mentioned in the contract. It was one of the terms of the contract that maybe if you don't pick your goods by this time, I will resell them. But for where there is an agreement to sell, it is clear. Once you for example, you breach the contract, a right of resale will definitely accrue. It's like when I have my matoke, I've called you to buy them and you don't. I can always get someone else to buy them. Then I'm looking at insolvency of the buyer before he pays for the goods. So if there is a contract of sale and the buyer becomes insolvent before he pays for the goods, then when you are the seller, what you're going to do is that you can make your claim with the official receiver. Official receiver is the person that takes over the estate of the insolvent once he has been declared by court to be a bankrupt. So in that instance, that is what is going to happen. And also, if he has not paid for the goods, then you can always claim for it as you'll be as a creditor. So you can claim from his estate as a creditor. But if there is it is just an agreement to sell, then you can always take your goods back, and you have no right to do what? You have no right to claim against his estate. So if we go to distinguishing this contract from other contracts, there are other contracts that happen, but if you are to distinguish them, for example, if you are to distinguish it with the contract of supply of services, a contract of supply of services is about services. Like, that is why for them they have a supplier and a consumer, or supplier and client. That is how it is. So it's different from the contract of sale of goods in that the subject matter is different. And also when you look at the parties, they are also different. We have buyer, seller, we have supplier, client, or consumer. And also the terms of the contract, really, they are different. For example, the implied terms that apply under sale of goods are part and parcel of the contract. There are also implied terms under the supply of services, like the duty of skill and care, and make sure you supply quality materials. Those are a bit different. So those are different contracts. Though the law of contract of sale of goods and supply of services takes care of all the contract of sale of goods and then the contract of supply of services. Also, we are going to see that there is a difference between a contract of sale of goods and bailment. When we talk about bailment, this is a process. Now this is a transaction where there is who we call a bailer and a bailee. So a bailer gives his goods or his goods to the bailee, and the bailee is supposed to keep the goods for a specific period of time at a fee. So sometimes it is paid for example, I can give a warehouse my goods and I'm telling them I don't have enough space, please keep them for me, and whenever I require them, I'll come for them. There you're just a bailee. You're just in possession of the goods at the fee. So it means that once they are required, you're supposed to bring them back. So that is the difference that is there, is that there is no transfer of ownership in bailment. Then there is a contract of hire purchase. It is almost like a contract of sale of goods. But the only difference that we have there is that when you're buying goods on hire purchase, the goods become the property of the buyer at payment of the last installment. So it means before the last installment, the goods still remain the seller's goods. So that is the difference between it and the contract of sale of goods. For a contract of sale of goods, once a contract is made, the ownership changes hands. So that is the basic distinction. This is what we call barter trade. I think most of us have heard about, since our primary schools, about barter trade, exchange of goods for goods. So that one is different because there is no money aspect. With contract of sale of goods, there must be money. Consideration must be money. Even in barter trade, where you find, for example, I give you a phone Techno, you give me an Infinix, and I have to add a balance, that still means a contract of sale of goods. For a barter trade, it strictly has to be exchange of goods for goods. So I hope you are following, I hope you are understanding, and you are enjoying the subject. So when we look at the contract of sale of goods, there is another interesting part of the contract of sale of goods, and that is the terms of the contract. So we are going to see that the terms of a contract can be it's one of those fundamental things that a lawyer has to make sure that they grasp. Why? Because you're going to be in charge of drafting these contracts. So there are types of terms that we have. We have a condition and we have a warranty. So they are defined under Section 1 of the Sale of Goods and Supply of Services Act. So a condition means an agreement with reference to goods which are the subject to a contract of sale, but collateral to the main purpose of such a contract, breach of which gives rise to a right to reject the goods and treat the contract as repudiated. So this condition, it is what we may call a major term. From your knowledge of contract law, a major term that if you by any chance breach, it gives the other party the right to reject the contract and treat the contract as repudiated. Then warranty, we are saying that it is collateral to the main purpose of the contract. When you breach it, it may give rise to a claim for damages. So a warranty, usually we look at it as a minor term. For example, I'll give you an example between these two. I can call maybe a seller abroad or seller of cars, and I tell him I want an Audi. So he sends me an Audi, but the Audi doesn't have, maybe the tires are old, etc. Or maybe some part of the car is a bit faulty. So in those instances, that is a warranty. It means that he will pay damages for repairing that damage. But there is when I ask for an Audi, and then you send me a Corona. That is a major term. So that is what we may call a condition. So I have a right now to reject that car, and it is taken back. Then we have express contracts and then implied contracts. When we talk about the express contracts or implied contracts, express is that this expresses the will of the parties. So they talk about it or they write about it. But when it comes to implied, these are terms that are presumed in the contract by law or by custom. This is how customarily you do things, or this is how traders do their things, or this is what the law mandates. So under the law, we have key terms, key implied terms, which are conditions, by the way, and they are mandatory. And the law is clear that you cannot negate them by excluding them. So even if you don't mention them in the contract, they still apply. And one of them is an implied condition as to title. What does that mean? That when you're going to sell the good, you must be the rightful owner. You must have the right to sell the good. So that leaves out the thieves, the rogues, those who want to take advantage or sell property that does not belong to them. And also this protected protects the trademark owners, those who have trademarks. So for example, you can't sell someone else's trademark goods which have a different trademark. So that protects the true owners of the goods. So when you are going to sell, there's an implied term that you are the rightful owner. And if you find that you're not, then the other party has a right to reject the goods. Then another aspect is that the goods shall correspond to the description. Shall correspond to the description. If I give you description, the description will talk about quality, quantity. We are talking about, for example, the measurements, the packaging, etc. So that one, when we talk about, if I tell you the quality that I want, the packaging that I want, then you must supply accordingly. If not, then I have a right to reject the goods and treat the contract as repudiated. Then there is sell by sample. Sample is when I give you a sample and I tell you this is what I want. So the law is clear that even when you sell by sample, the sample must correspond to the sample that was given to you. And the language that is used in the act is that shall correspond with the sample. So it means it is mandatory. When the law uses shall, know that it means that is mandatory. And so when it is by sample, then you should. But sample, it means that you gave this person, you gave the seller a sample to use, to look at. And then you have the chance also to examine whether the sample that you gave him is what he has supplied. So there must be some examination from the buyer. Then there is also an implied term as to both by sample and description. So it means that sometimes a person may give you both the description and also give you a sample. So what you bring shall correspond to both sample and description. Then there is quality and fitness for purpose. When we talk about quality, we talk about satisfactory. The act talks about satisfactory quality. So when you talk about satisfactory quality, we are looking at what a reasonable person, for example, that deals in that particular good, if they would say that good is satisfactory, is of quality. Then fitness for purpose. When you talk about fitness for purpose, I may have a wedding and I want a gown. So I will just tell you, by the way, I have a wedding and I want a gown. All right. So if you bring something that is not fit for the wedding, then that means that you have brought something that is not fit for the purpose. But for you to rely on this implied term, one is that you must deal with people. You can't be looking for wedding dresses and you look for someone who sells matoke. So you must look for someone who deals in the sale of that particular good that you are interested in. And then that person, when he brings it, must be dealing with, in that particular good, he must be selling those goods, not a one-off. It must be his kind of what? His kind of business. Because remember, you're relying on their skill and expertise. So make sure that you tell them, first of all, the purpose, why you want the good. And then as you rely on their expertise, you have to make sure that this is what they usually deal in. And if you have multi-purpose goods, make sure that you tell him exactly the purpose you want that good for. Right? They are single-purpose goods, but they are also multi-purpose goods. For the single-purpose goods, you may not need to tell them. But for the multi-purpose goods, you have to tell them the purpose, why you want that particular good. So then it has to be merchantable. The aspect of merchantability, it has to be something that is usable, something that is good. And when you look at it, sometimes I do not need to tell you that I need a shirt that has buttons. You already know that I have to have a shirt that is usable. So we have to look at briefly at the duties of a buyer and seller in the circumstances under a contract of sale of goods. One is that you have a duty to take delivery of the goods. As a buyer, if they bring goods, you have to accept them. It's, for example, someone taking a whole truck from Kabale to Kampala, and when you reach, you say, I'm no longer interested in the goods. Then that means you have breached the contract, especially if you have already agreed to take the goods. Then you have a duty to pay the price. So you have a duty once the goods are delivered to pay the price. Then as a seller, you have the duty now under Section 34 of the Sale of Goods and Supply of Services Act to make sure that you deliver the goods. And also you have a duty to deliver the right quantity. Not just delivering, but delivering the right quantity. So those are the duties of a buyer and of the seller. And when you look at buyer protection challenges, because when this act was being introduced, basically it was looking at protection of the consumer also. So there is what we call the doctrine of caveat emptor. The doctrine of caveat emptor means let the buyer be aware. Let the buyer be aware. So once you're buying a good, they're assuming you're aware. For example, you buy a shoe, but when you reach at home, it does not fit you. Yet when you tried it on, it was fitting. You cannot take it back. Why? The doctrine of caveat emptor. Let the buyer be aware. So sometimes the protection challenges come in because first of all you saw the goods and you took them home. How do you say again that you do not want them? So that is the doctrine of caveat emptor, and somehow it makes the protection of the buyer very, very difficult. Because they are saying you saw it, so you shouldn't complain after seeing it. Then inexperienced sellers, we also have inexperienced sellers sometimes. So they are not able to advise us, the buyers, very properly. So that also can be a challenge. You're buying something you're not very sure about, and also the person selling it to you is not sure about it. So that brings in a dilemma. Then also limitations concerning examination. You buy things, they are in, for example, it is a ton of goods and then they are in packages. How do you tell that this one is good and this one is not good? It is like buying tomatoes. How do you know that this one? Sometimes you buy a tomato and when you reach home, this tomato is rotten inside. But you couldn't tell at the time. So there is an aspect of limited examination. And then the doctrine of privity of a contract. It means that once you buy from a third party, you cannot sue the owner. For example, the doctrine of privity of a contract is to the effect that only parties to a contract can sue. But I may buy a product and give it to the third person, and the third person is the user, and the user cannot sue. Why? Because they are not the ones who bought. So that brings challenges. Then also court processes are costly and time consuming, which has sort of hindered the buyer protection because they look at going to court. That would take their time, even the business they are doing, so they end up giving up on the whole issue. And then majority of the buyers are also ignorant. That is also an issue. You may sue, you may challenge, but you're also ignorant about the issue at the end of the day. So that brings in a challenge. Then also sellers, also some such as hawkers, have no fixed place of business. How do you sue someone? You bought from them something on the roadside and now you cannot even trace them. So that also is a challenge as far as Uganda is concerned. So we are going to go to our last part. Briefly talk to you about the supply of services. So a supply of services covers agreements where the supplier simply provides a service. All right, a service. And when you go to section 1, it talks about tourists, it talks about hotels, it talks about car wash, it talks about various. So when you read section 1, to give you what is a service. So if you are in a media industry, you are in a tourism industry, you are in a hotel industry, car washing, dry cleaning, salon, hairdressing. For example, if I come to make my hair and you burn it, I can sue you for negligence, and I can sue you under a contract of sale of what? Sale of goods, because you are supposed to exercise due care and skill when working on my hair. So that is what we may look at the supply of services. And when we talk about supply of services, it also includes a contract where the provision of service also involves the transfer of goods. For example, a service may also involve a good. For example, transferring goods repairing a broken screen or of a microphone. So it means that they brought you the good, which is a microphone, and your job is just to repair it. So in such instances, you have done a service, though there was a good involved. So when we talk about under the sale of goods and supply of services, there is what we call an implied term as far as these services are concerned. One is that there is care and skill under Section 18. So whatever you do, if you're giving a service, make sure you exercise due care and skill. Then also the time of performance. If no time of performance is mentioned in the contract, then it is implied that you do it in a reasonable time. So reasonable time depends on the circumstances. So you can actually make sure that within a good time after the contract is made, you are able to provide the service. Then also there is an aspect of consideration. When you do not agree about the price, about the consideration, then you can always, when you don't agree about the consideration, you can pay what is reasonable. So it's like when you bring me, you do something for me, and then you do not tell me how much to pay. I can pay something reasonable here. That is what the law is saying. And then also there is an implied duty as to the quality of materials used in the contract for the supply of services. If you're doing the service of construction, you have to make sure that the materials you're using are of quality. Are of quality. That is what you have to make sure of. Then when you look at the duties that the supplier has, he has the duty to supply the service, but not just supply the service. You have to supply it with reasonable care and skill. The reason I came to you for a service is because you know how to do this. The reason why I may come to you to construct my house is because you know how to do it. So you are supposed to make sure that you do it with reasonable care and skill. Then for the consumer, our client, all he has to do is pay for the service. So once a service is given, no need to you pay. It's like when I go to the salon, after doing my hair, I have to pay. There is no bargain about that. So that is how the supply of services works. So this is something that was introduced in 2017 under the Act, and I believe that right now, if I go for a service and it is not really, they don't exercise care, and something happens in the process, I have the right to sue under the contract of sale of goods and supply of services. There will be more to add, but for today, this is what I had. Thank you for attending and thank you for listening.